we have a very nice introductory lecture that fits quite well. As you know, Herfried Wöss is the co-author of the Oxford University Press monograph on damages in international arbitration and the complex long-term contracts. So who could be more competent to begin our webinar today by talking about ESG-related damage claims in international commercial arbitration and the applicable law. Herfried, you have the floor.
Thank you, Markus. So I will deal with 4 topics today. From the outset, I have to tell you, damage is related to the due diligence, to CSDDD. Sorry for the acronym. It was explained the last week. Is highly complex. So it's not the typical contractual non-performance situation. It's much more complex, where you have issues of applicable law, we have issues of standing jurisdiction, where you have a heavy element of tort law claims as distinguished from contractual claims. And the contractual side, I would say it's still very diffuse. It's not clear, it's not clearly defined, and I hope within the next 30 minutes I can put I can shed some light in this topic. So the first issue is from soft law to hard law remedies. This is not, I want to refer to the source of this information. It was a very recent publication in the Columbia FDI perspective, which I recommend you to read, on the strategic use of the OECD guidelines for multilateral enterprises, which is citing a couple of cases that are highly relevant. So to start with, let's dig in some cases. FNV versus New Energy complaint filed by the Federation of Dutch Trade Unions at the Dutch National Contact Point, NCP, for human rights and environmental measures, alleging that the energy company had breached the guidelines, the OECD guidelines for multilateral enterprises, and the United Nations Guiding Principles on Business and Human Rights, labor employment provisions, by paying foreign workers less than Dutch workers performing the same duty. And the court case was won. So that's an example how what used to be soft law guidelines is becoming hard law by being converted into a diligence standard through national courts. So we are not yet at arbitration, but the development is highly interesting, and it goes very, very quick. So most of the material I'm citing today, even if I do not put the footnotes, are absolutely recent. Yeah? The other case is Milieu Défensif versus Royal Dutch Shell. I understand that has already been tackled last week and will be tackled today again. The applicant argued that the company owned a duty of care to address its climate impacts based on soft law standards, including as contained in the guidelines and UNGPs. In May last year, the Dutch court found that these standards do form the basis of care under Dutch tort law. So again, converting soft law in a standard of duty of care under Dutch tort law. Dutch law is one of the very modern civil laws, together with, for example, the Quebec law. NCP brokered agreements, Sherp et al. Versus Bolloré. That was an agreement that was already brokered by an environmental organization, put in writing. There was an agreement that the shareholder Bolloré of the palm oil company Socapalm would exercise its leverage to encourage remedy of Socapalm's negative impacts on the environment and labor rights. That was not honored by Bolloré. So agreement between shareholders and an association that was not honored, where the shareholders obliged themselves to press Bolloré, which is the company, their shareholders. They didn't do it. Sherpa, the organization, sued Bolloré in a French court, requesting enforcement of the NCP mediated agreement under French contract law. The case is still pending. And Global Arbitration Blog, a report by Emily Hay, December 11th, 2022, on ESG clauses and dispute risks. Highly interesting because she refers of a rather extensive program by the American Bar Association business law section. And that is very important because the first thing is when I started working on that is, well, I need something more tangible. This due diligence directive, it's not really clear where the liability is, what's the but-for situation by not doing due diligence and things like that. So as a practicing lawyer, you want to have tangible information, draft contracts, draft clauses, draft codes of conduct. And this you can find here, actually further on the presentation. I put the hyperlink to that document. So the American Bar Association Business Law section drafted extensive documents under US law and, what is more important, CISG. And I can tell you already, the whole supply chain contractual topic will be a revival of CSG, which for my country, men and women in Austria and also many German lawyers is still often unknown territory. So we're still seeing practice in Germany, in Austria, where CSG is opted out. Actually had a nice construction machinery arbitration in Frankfurt under German law, not CSG, sales of large construction machines. Well, thanks to the Vienna University of Economics and Business, I got hold of the German commentaries, and I thought, well, I have the Schwenzer commentary in my office, and now I sit in the Viennese library of a major university to get through German law because the Germans just opted out of CSG, which of course makes arbitrations much more expensive. So we'll see lots of CSG in these supply contracts. And that also means, of course, that the work of the American Bar Association is very useful because it's drafted under the CSG, taking into consideration, of course, US law, which means more explicit, more extensive wording because of less legal background, less legal precision. But anyway, the available legal documents are not precise either. So it's very, very useful. These clauses, recommended clauses, are to be inserted in the supply contracts, purchase orders, or similar documents for the sale of goods. There is a set of model contractual clauses, the ABA, American Bar Association, MCCs 1.0, and there are alternative clauses that have been worded in 2021, the 2.0 version, and that is accompanied by very extensive explanatory documents. I recommend you dig into it. That's where you find concrete contract clause recommendation, codes of conduct that you can already use and adapt to Austrian law, adapt to German law, and of course, do not forget about CSG. Then there's the Chancery Lane project under the laws of England and Wales, more than 100 model clauses for various types of contracts, incorporating ESG obligations tailored to the type of contract and to specific climate-related goals. And then we have our due diligence draft directive, where it is already announced that the European Commission will adopt guidance about voluntary model contract clauses to support compliance with the obligations under the directive. So that's where we are, starting point, and the most tangible one is the American Bar Association specialized sub-web page, and I recommend you get into that. This issue is coming more quickly than perhaps the European directive, and that's what has to be written into supply contracts today and not tomorrow. So what's the disputes in ESG, the likely disputes on the contractual side? Well, first, interpretation. There's a risk of broadly drafted clauses or those with imprecise language. The issue of material breach of ESG clauses, material breach as a term under CISG. Then we have the issue of the directive once transposed into the national laws of the European Union member states. That is mandatory law, Eingriffsnormen. So that will have impact on arbitrations, even then governed by different applicable laws. So that's another source of disputes. And then, of course, we have a lack of standardization. We have conflicting norms The European Union is pushing ahead, but they are not the only power player in that field imposing its own standards. So we know that the European Union has quite some experience in imposing international standards, but will see competition. So we might have different rules of mandatory law applicable to the same contract. And again, there's a lack of standardization and consistency in ESG metrics that will cause disputes. And furthermore, and that was the first impression I had of the ESG when Professor Adolf Peter addressed me and said, you know what, that's a huge flood wave. We have to do something. Let's organize a seminar with the top people in that field because it's inevitable. It will touch upon everybody. But of course, we have to make sure that the ESG rule really are effective and efficient with respect to climate change. And what we know, it will be expensive to comply with the European directive. So it's an onerous obligation of companies. The sheer size of tasks to be performed in order to comply with due diligence obligations will certainly lead to disputes. And then, of course, we have the issue of third-party conduct that is involved in all these situations, because we have to make sure that the whole supply chain downwards, as was explained last week, these rules are being kept and observed, and the due diligence obligations, of course, aim to that observation. So when there's a third-party conduct issue, we immediately are confronted with the limits of arbitration clauses, the difficulties in gathering evidence, and the likeliness of parallel proceedings. And then, of course, we have evidentiary issues in causality, the role of expert evidence in professional auditing, so in new industries being created in audit firms in order to audit the whole supply chain and to comply with the due diligence obligations. And of course, causality, for example, just as a keyword, I won't go into detail, the precautionary principle with respect to technical issues, environmental issues, which leads to a kind of reversal of the burden of proof and things like that. But on the other hand, we know from the point of view of damages law, the burden of proof and the standard of proof are of utmost importance. It's not that easy to reverse that, because that would actually be hit against systemic issues of our legal systems. So causation is a major issue. And then, of course, I haven't put it here, what's actually the damages? And there, be careful. When the directive talks about the damages, we talk about the loss, so we talk actually about the effects on a protected good. So most of the civil legislation still need that the protected good is affected, which is property, life, environment, and other issues, which is not the thing of contractual non-performance. So you need an additional requirement to that. And the damages, which is the compensation. So same word, add an S, something completely different. When we talk about damages, we talk about compensation. In case of environmental impacts, it's still repair. Yeah. So I gave a conference 2 years ago in Ecuador, and basically you calculate how expensive it is. What's the cost of cleaning up 1 cubic meter of earth that has been contaminated? So the basic approach is cost of repair. And we do not talk about lost profits. We do not talk about discount cash flow method, nothing like that. It's cost of repair. But of course, what's the cost of repair to get our world climate straight again? And is there any responsibility to anybody, or how does that work? So there we come to areas that are not explored yet. Okay, ABA model clauses, as I mentioned, there's the hyperlink. And these model clauses include, for example, provisions on human rights due diligence, on bias responsibilities, and remediation. And again, if you look for something precise, you find it in that webpage that is cited at the top. I won't go into detail. I'll leave that up to you. For example, and just example for lawyers, practicing lawyers. I copied one of these clauses in the drafting document. It's a Word document of, I don't know how many pages, but pretty large. Mutual obligation, the title is Mutual Obligations with respect to combating abusive practices in the supply chain. As of the effective date of this agreement, buyer and supplier each agreed. And then you have human rights due diligence, copied just at the beginning so that you see it. You have footnotes with very extensive explanations of how lawyers should draft these clauses. So that's a drafting document. That's a document that helps lawyers, in-house counsel, attorneys to draft those clauses. And also here an example of the model code of conduct. I understand Adolf will refer to that. So here have a model code of conduct, very useful document. Buyer recognizes that it has an obligation to respect human rights throughout its supply chain, in particular with respect to those human rights and principles enshrined in the United Nations Declaration of Human Rights. So that's the general wording, but then it goes really into detail. What does it mean on a contractual level? We're not talking now about the directive. We're talking about contractual documents. How do we execute these obligations on a contractual level? Okay. So with that, we finish the contractual part and we go over to the directive. But again, the contractual part, what is missing here, I didn't put it in the presentation. CISG is rudimentary with respect to damages. Yeah, CISG, for whatever reason, and the same is with the UNITRA principle, still uses the outdated distinction between loss and lost profits, damnum emergens and lucrum cessans. And as we proved in the 2 chapters we wrote for a book that came out last year, which was edited by Nikos Lavranos and another colleague of his, we proved that the distinction between loss and lost profits was introduced by the Catholic Church under canon law in the Middle Ages in order to help the upcoming Italian, well, there was no Italy, but Italian and German banks, the Fugger and Welser and the Medici, because canon law by that time prohibited interest, the same as Sharia nowadays. So they had to find a way around the interest prohibition in order to get money if a loan wasn't paid. You can read that in those book chapters. The book is called International Arbitration and European Law and was published by Edward Elgar Publishing. Okay, so CISG is rudimentary with damages law, but still you can apply the differential hypothesis, Mommsen's differential hypothesis, or what in English is called the but-for premise, which is the gold standard for damages, for contractual damages, Erfüllungsinteresse oder Vertrauensschaden. I won't go into detail that. You can read that in our book. It's complicated. So let's swap now to government regulation, the draft directive of the European Parliament and of the Council of February 23rd. And what is more important, the Council has modified the draft directive in a substantial manner on 30th of November. And thanks to Marcus, who touched that issue last week, I figured out that, well, the text he cited didn't compare to that of the Parliament's directive, and it's true. There was a total change by the Council and adapting the whole thing to basic elements of civil law and on the continental civil law. So Article 22, which is about civil liability, has been significantly amended. There are 4 conditions now: a damage for company to be held liable, a damage caused to natural or legal person, a breach of a duty, the causal link between the damage and the breach of a duty, and the fault were clarified in the text, and the amount of fault was included. And that's interesting because under modern systems like German law, CISG, UNITRA principles, there is no fault for damages anymore. Yeah, that was replaced by a guarantee function. So going back to fault, it's interesting, but of course it's being explained because of the tort law aspect of these issues. So the directive also speaks of full compensation without actually putting examples what it means. Again, what I've seen up to now and reading some literature on environmental damages, it's cost of repair. So it's a completely different issue of income generating contracts, investments, and assets that we see in investment arbitration. Here, we're in the tort law field, which is a different world from the contractual investment world. So it's basically cost of repair. But yeah, it's underlined full compensation. So for everybody who thinks Chorshov is dead because it was for a particular situation, no, Chorshov is the result of a couple of 100 years of legal development in the damages field, and full compensation, that's it. Yeah, nobody questions it. And here it's again. What, of course, full compensation means: no undercompensation, no overcompensation. So we need a bandwidth that is fair, neither below, neither higher. And that's what some authors always forget when they tend to argue for overcompensation, because populistic politicians have to be protected, yeah, when they damage their own people, like is such as the case of Mexico, for example. So what is not allowed is punitive damages. That would be overcompensation. So the directive also refers to harmonization. Now being very quick, and then it has a kind of, yeah, and then what is important is it refers to the obligations lined down in Articles 7 and 8, and of course all the obligations in Annex 1, as we heard last week. That's all these conventions, large lists of convention with different obligations. Yeah. And then you see, and 7 and 8 is kind of ambiguous obligations, and it tends to due diligence. Yeah, and that's the first observation I want to make. I don't see like direct, clear-cut obligations. Yeah. And don't forget, when we talk about damages law, the question is always, what would be the situation of the injured party without the violation? Yeah, so that's the standard formula that you have to ask yourself in any step of damages analysis. Don't get into that, but damages analysis is pretty complicated. Yeah, and in each step you have to ask the same crucial question: what's the position of the injured party in the absence of the breach, yeah, or the violation of an imperative norm? Yeah, and if the obligation is due diligence, so the question is, well, if the due diligence had been performed, would the damage have been avoided? And perhaps the answer is no, because the damage is violation of labor laws, human rights, environmental damage, and with or without the due diligence, that could happen. Yeah, so you have to be very precise with the but-for premise, with the hypothetical, with the differential hypothesis question. Yeah, so there is no liability for the actual result. It's an obligation of means, it's an obligation of care, and the key issue is the due diligence obligation. Yeah, so if you hypothetically, you say, well, I would have, if I had complied with the due diligence obligation, would the damage or the violation of human rights have been avoided? Yes or no? If it's no, well, then there's no damage. There's no causality either. Yeah, because under the but-for premise, the causation test is actually incorporated in the but-for premise. Okay, so let's just jump further. But that's, I would say, that's one of the key issues. And again, the obligation is an obligation of means, not of result. Under tort law, there is a need of violation of protected goods, at least in Germany, Austria, and many other civil law countries, property, health, environment, and not mere financial loss. So the rule is always, you cannot get damages of mere financial loss, though I know a German professor in China who wrote his Habilitation, his postdoctoral thesis, saying, well, you can have damages also for financial loss, for example, intellectual property. So I always say this is one of the scientific complications of civil law, which I would say they are rather unnecessary, but that's it. Don't ask a professor of tort law. I would say that's a golden rule, but it makes it more complicated. So it's more difficult to ask for damages because of the structure of tort law in the continent, on the continent. Yeah. Cost of repair is the measure of damages, which is fairly easy to calculate. But again, if someone is asking what's a company's contribution to the climate change, then it becomes difficult. Yeah, and then we come to kind of this precautionary principle and other items in order to prove causality. Okay, so let's jump. I'm running out of time. Yeah. Then there's some interesting things like, damages regime, indirect relationships. So there are subtopics, that you have to be examine very careful, and that's the extract already of the revised directive revised by the council. Standing, for example. As I mentioned, one thing is contractual change. Go to the American Bar Association, check how you draft your contract, but the large part of cases will be somewhere suing the compliance of the directive in whatever European Union country. And then what the directive says, even if the national law does not contain civil liability as it is, correct me if I'm wrong, Marcus, I think Germany, there's a difference between France and Germany. Under the directive, all these countries have to incorporate in their national law provisions. They make sure that you can sue that. Of course, the standing jurisdiction, that is a matter of national laws and can be pretty different. Okay, and also don't forget, even my partner is member of the ECASIL Task Force on Damages in International Arbitration. The truth is there is no damages law. There are many. Each jurisdiction and also the transnational law rules like UNIDROIT principle have their own measure of damages. So you have to be very careful. Even if you ask for the same thing under the directive, you might get different results. In particular, if you're, for example, in the Netherlands, you will have perhaps a very generous result. The same in France, the same in Germany. We have seen it under Vattenfall. German courts work similar to an investment arbitration tribunal, but there are other countries where you perhaps don't get anything. No? So adverse impacts, member states shall ensure that companies take appropriate measures to identify actual and potential adverse human rights impacts and so on. To bring them to an end. That's one of these areas, Article 6 and 8. Yeah, Article 6 and 8, let's say that's the substantive provision that all these due diligence obligations circle around. But if you read them, bring adverse impacts to an end. How do you do that? Through a due diligence obligation? Well, it says mitigation, or you just do not buy from the people who are violating, or the companies who are violating human rights by employing children or whatever. So that's how far it goes. But again, it's not that damages are for the violation of human rights with respect to child labor. It's because of not having terminated a contractual relationship with the company somewhere in Africa or wherever that uses children to dig for diamonds, things like that. So they're quite sophisticated questions when you come to damages, where each word you're reading here, I can't go into detail, is highly significant. So you're not responsible for the actual violation, but for not having terminated. Again, but for question. Okay. Then what else we have? Civil, the less burden with respect to indirect partners, all of that. So we come into details that are not that relevant. Let's check if there's something subsidiaries. Effective compensation. Again, states are being obliged to put into the national laws these civil liability provisions, even if it's not there. And the other thing is, if there are parallel obligations or civil liability for environmental human rights violation, that's without prejudice. So at the same time, you can have much higher liability under other rules than you might have under this. The problem is then, do you pay the same? Is the compensation then kind of taken into consideration, or is there double compensation for the same violations? I didn't find the answer, so that's something that has to be litigated and checked. And again, full compensation, causality. Causality is not regulated by this directive. That's very interesting. As I mentioned, the normal causality, the best practice of causality is the differential hypothesis. Had the injury, the damage occurred, the loss occurred, even in the absence of the breach. It's a very simple formula. But of course, that has to do with causation theories. Causation theories under English law are totally different from the hypothetical normal course of events that is, for example, under German law and Austrian law, and under international law, because the Trosso formula also refers to the hypothetical normal course of events. So that's details I can't explain. Time is too short. But what I want to say, the different causation theories and the different applicable laws, and the directive expressly says causality is not regulated by this directive. And you can come to totally different outcomes if you can prove that the damage was caused by an interfering cause or an alternative cause. You're basically out of the trouble if English law applies. That puts emphasis on interrupting and alternative causality, as different from German law that doesn't care of extraordinary circumstances and things like that. So is there anything else? Yeah, burden and standard of proof is not regulated either. Standard of proof is often neglected, highly relevant. You put certainty, you don't get damages. Yeah, you put probability, you might get significant damages. So by raising or lowering the standard of proof, you change the amount of compensation. And there is quite some issue on standing jurisdiction, joint and several liability, stricter liability on alternative claims. And of course, in the end, if we go back from tort to contract, if there's a tort liability, you might go for an indemnification claim. So we come back to the contractual relationship. Yeah. So you get hit by a lawsuit for tort under the directive, and it results that someone else, some other company in the supply chain was responsible for that cause. So then you go for an indemnification provision, which would be provisions clause 6.5 under the ABA model clauses. And with that, I finish. Thanks for your attention, your interest. As you have seen, it's a hell of complex area, and damages is normally the most complex of any kind of these issues, much more complex than the regulatory part or the typical contractual part. Thank you very much.
Thank you so much. Thank you for this overview of what is really a very complex subject matter. And indeed, as you mentioned, to some extent, the directive proposal brings together the regulatory approaches of the French Loi de Vigilance and the German Supply Chain Act by taking both the civil liability and an administrative penalties standpoint.